Hello, everyone. Welcome to the Blue Book Records. So, for citing cases, you'll have the first party, V period for verses, and the second party. Now, all of this is in normal text. Comma with a space, the volume number, the reporter volume number, with a space, and then the reporter abbreviation using the conventions for that we talked about for abbreviations, then a space. Then you'll place the first page of the case, followed by a comma, and then the specific page referred to, or the pin site, with a space, and the date of the decision in parentheses. You can also add more information throughout, but this is basic. The first example they have in Rule 10 is a citation to a U.S. Supreme Court case. So if we look at it, we have the first party versus second party, comma, reporter volume number, U.S. This is an abbreviation for the U.S. reports. The first page of the case, in this example, it's 57, followed by a comma, our pin site, and then the date of decision in parentheses. And there's no court listed in the parentheses because this is implied by the reporter abbreviation. Now, if we look at the second example of a Court of Appeals case, we have the parties. We have the first party versus the second party, reporter volume number, and then the reporter abbreviation using our the style according to the rules we talked about before. So this is the Federal Reporter second series. So notice we have F period 2D. There's no space. So our rules being if there are two single abbreviations, then there's no space there. And then our rule that if a number counts as a single letter for purposes of that rule. And then we also have a rule saying that if it is second or third, that we drop the N. So here we have F period 2D with no spaces. Then we have the first page of the case, followed by a comma. Then in this example, we have the span of specific pages, 199 to 200. And then in the parentheses, we have the year of decision, and then we have the deciding court, right? And in this specific situation, it's the Fourth Circuit. So we have 4TH. We don't use superscripts, and circuit abbreviated according to our conventions. Now, there's also part of this citation example. It was reversed. So we have the abbreviation for reversed. And remember that we have when a abbreviation ends in an apostrophe or contains the apostrophe, we don't put a period. So we have reversed with no period, comma, and then the citation of the reversal. So in this case, we have 435 U.S., 850, 1978. This is a U.S. Supreme Court case, so the court is implied by the reporter, so we don't have to put anything about the Supreme Court case. Now, short forms. And remember, these are all in regular text. So after the case has been cited in full, you'll just do the So the short form for the case we just cited, we have the shortened case name in italics. We don't use the government party with a comma. And then the abbreviation for the volume and reporter, we just have volume number, reporter abbreviation, and then at, and then the pin site. We don't put the first page on which the case is included. So that's kind of a basic overview. Now to dig deep into citation forms. So in Rule 10.1, there's a chart that goes over the basic citation forms. So if a case is filed but not cited, cite it as such. There's unpublished interim orders, published interim orders, unpublished decisions, decision published in service only, decision published in newspaper only, etc. Then we have, of course, published decisions, and let's see, petition for cert filed. So we have a comma, and petition for cert filed is in italics, and cert granted, etc. So if you're dealing with cases, I would look at this first, Rule 10.1, kind of have this bookmarked ready to go. So now digging deeper into the case names. So the difference between the case names in textual sentences and case names in citation, of course, the italics, right? And the abbreviation. So for example, if we are referring to a case in the text, it's in italics, right? And we'll cite it the same. That is with first party, second party, volume number, reporter abbreviation, the case where the page where the case first appears, and then the year. If we just refer to the case and we don't have the citation, we will refer to the party, the non-government party, in italics. What we don't do is we won't abbreviate either, right? In text. So we only will do that in the citation. So in the citation, again, no italics for case names, and a cite according to what we discussed before. So if we have a situation where the case is consolidated by two or more actions, you only cite the first one listed. Same thing if there's we get rid of all the parties other than the first one that's listed on each side. So section B, procedural phrases. If there is, we abbreviate terms like in the relation of, for the use of, on behalf, as next friend of, and things that are similar to that, to ex-rel, ex space rel period in italics. You will include introductory phrases like the estate of, the will of at the beginning, and these are not in italics. And procedural phrases are always italicized. And abbreviations. So in the text, in the main text or footnote, we will abbreviate under Rule 6. This is what we talked about. And then there's 8 more words. So ampersand, you'll see them under section B. So we have association, brothers, co, corp, inc, limited, and number. So if the exception is if any of these begin a party's name, then you won't abbreviate it. So the, we get rid of the as the first word in the party's name, with a couple of exceptions, where it's cases like the king or the queen, or if it's relating to some sort of property where you're talking about the so-and-so bridge. And you wouldn't omit the if it's in a popular name, right? So Blue Book gives an example, the civil rights cases. Descriptor terms. So terms like administrator, appellee, executor, licensee, these kind of words can be omitted. So there might be a case against an administrator, and so against a person in their capacity as an administrator, not against this person personally, but you'll get rid of the title. Geographical terms, this is in F, subparagraph F. We omit state of, commonwealth of, people of, in case names. Same thing with city of, county of, village of. Again, we're omitting prepositional phrases of location or similar expressions, unless it makes the party name ambiguous. Given names or initials. So this is G. So in general, we omit given names, meaning our first name. And we would only use surnames. So business firm designations, this is an H. So we would get rid of those designations if it's already clear that the name also contains a similar word, like association, co, corp, or railroad. So there's an example, Wisconsin Packing Co. Inc. You get rid of the Inc. And it's just Wisconsin Packing Co. v. Indiana Refrigerator Lines Inc. So subsection I, union and union names. We cite the union name exactly as it is in the reporter, given a few exceptions, in that only the smallest units should be cited. So sometimes there are abbreviations that are appended to the end of a union name. Those are omitted. Common names. This is K. That is in situations where there's a common name for the case that's known and the reporter name is not so known. So this, you would use the common name in the parentheticals. Blue Book also mentions that you can totally get rid of it. But I would use a parenthetical. So 10.2.2, additional rules for case names in citations. So they mention you need to abbreviate words according to the table in T6. And mentioning even if it's the first word in a party's name. And finally, abbreviate other words of 8 letters or more if substantial space is saved and the result is unambiguous. And this is so you should always consult table T6. Now, 10.3, reporters and other sources. So 10.3.1, parallel citations, and this conundrum of which source to cite. So table T1 for the federal and state jurisdictions, T1, this indicates which reporters to cite for the decisions in most of the courts. A lot of decisions are published in 2 or more sources. And I recall if you do a copy in Westlaw, the copy will, at least the last time I looked, I think it might include both sources or all the sources, but refer to table T1 to figure out which one to cite to. Now, of course, if there's local rules, like if you're submitting it to state court, you need to follow the rules in citing court cases. Right? So the local rules always will trump the citation rules in table T1. So, but in all the other documents, like memorandum, law review articles, cite the relevant reporter in using T1, table T1. Now 10.3.2, reporters. So the publications that print cases or cases and annotations are considered reporters, and they are in normal type. So you'll have a volume and the abbreviation of the reporter, and check out table T1 for that. And then you'll have the number on the page, or the page on which the case begins. Again, we're looking at Rule 3.1 for the volume designation. Go to Rule 6 to look at abbreviations for the reporter. Now, this 10.3.3 public domain format, when you're citing a decision in this public domain format, you basically still want to provide the case name, the year of decision, and the state's 2-character postal code, and you can find this in Table 7. The court abbreviation, unless it's the highest court, the number of the decision, and if it's unpublished, you have a capital U, and then the number of the decision. So there's an example under 10.3.3 of a few public domain decisions in public domain format. So now, sometimes a jurisdiction will adopt a format different than what Blue Book recommends, and Blue Book recommends using that format rather than the Blue Book format. So now Rule 10.4, court and jurisdiction. So when you're citing cases, you have to include the court that decides the case. So in the United States, we'll name the court and its geographical jurisdiction, and of course we'll abbreviate it. In a parenthetical phrase following the citation, and then you include the year of the decision. So for federal courts, in citations to the U.S. Law Week, we use U.S. For Supreme Court Reporter, and the U.S. reports, we omit the Supreme Court's name. So when citing to the U.S. Court of Appeals, so for the U.S. Court of Appeals, use the abbreviations that are in the Blue Book. So for example, the D.C. Circuit is D period C period space CIR period. You have the Federal Circuit. For district court cases, give the district, but you don't need to give the division. There's abbreviations for the Foreign Intelligence Surveillance Court and Court of Review that you should follow, bankruptcy courts and bankruptcy appellate courts, according to subsection C. A. So then looking at B, state courts. So we need to indicate the state of the court decision followed by the year. You don't need to include the name of the court if it's the highest court in the state, right? And abbreviate according to the Blue Book as well for the state name. Now, Rule 10.5, date or year. Blue Book says, if possible, provide the year of decision. I would say always try to use the year of decision. Now, if there are multiple decisions within a single year, then we only include the year, the last cited decision of that year. Now, parenthetical information regarding cases. So, in parenthetical information, you can provide information relating to the weight of the authority. And it might be added in a separate parenthetical following the date of decision. So when a case is cited for something that's not the majority, indicate that in a parenthetical as well. So, for example, the dissent. And remember, the dissent we're looking at Rule 9 for judge names. So when you're in a parenthetical, you have last name of judge, comma, and J, comma, dissenting. Now, information regarding related authority can be included, or subsequent history. That should be included in a parenthetical as well. Sorry, information regarding related authority or prior or subsequent history that you can put in an explanatory phrase shouldn't be in a parenthetical, right? And there's two examples. So, citing and quoting parentheticals in case citations. If we are citing or quoting another case, and then we need to point to that to make a point, then a parenthetical should be used, and consulting Rule 1.5. Now, order of parentheticals. This is 10.6.4. There is a specific order after parentheticals, right? This is after the year of the case. We start with the weight of authority, parentheticals. Then we go to quoting or citing, parenthetical. Then we go to explanatory parentheticals. And we discussed this in Rule 1 as well. Now, prior and subsequent history. This is Rule 10.7. when we are citing a decision in full, we need to give the subsequent case history in the citation. But Blue Book says that we omit denials of cert or denials of other appeals, right? Or unless the decision is less than 2 years old, or the denial is relevant to the point you're trying to make in your article. We also omit history on remand and denial of rehearing unless it's relevant. So Rule 10.7.1, explanatory phrases and weight of authority. We have a kind of list in Table 10.8 of explanatory phrases. So this will include phrases like amended by, affirmed, argued, cert denied, cert dismissed, those sort of explanatory phrases. So always have Table 8 ready to go. So put the subsequent history of the case as part of the primary citation, and we will use that in italics between each citation. Right. Now, subsection B, significance of disposition. We give the reason for disposition in italics if it's significant. Same with overruled cases. We need to indicate whether a later decision by the same court repudiates the earlier decision. We indicate this by overruled by. Abrogated cases, cases that are abrogated or there's a significant departure from or by a later case. We need to indicate that with the designation abrogated by. So we have the first case followed by a comma, abrogated by in italics, and then the case that abrogated it. So cases superseded by statute or constitutional amendment. This is Roman 3. So when you cite cases where a statute or amendment was enacted with the intent of reversing the outcome of an initial case, you always need to cite that statute or amendment. Right? We say this by superseded by statute, and then name the statute. Right? Now, subsection D, multiple dispositions. This is if there's multiple dispositions in the same court, use the connector and in italics. So now you might have a situation where there's a different case name on appeal. You'll need to indicate that with the new case name and introduce it with SUB NOM period. And also, there might be a situation where there's a name change in prior history. And check out subsection B for information on citing that. And then special citation forms. This is Rule 10.8. So you might have pending and unreported cases. So in this situation, the case might be unreported but available on an electronic database like Westlaw. You can cite to the database. You provide the case name, the docket number, database identifier, court name, full date of the most recent disposition. So there's an example here where they're a citing to Lexus here. So usually the case will also include a code or a number that will identify the case. And Lexus, Westlaw, and Bloomberg has these. So in the example they give under A, so we have Gibbs v. Frank, then we have that unique identifier followed by the year and the database identifier and the number, the pin site. So there might be some situations where the database identifier is not clear from the database. You would include this at the end in a parenthetical. There might be a situation where the case was depublished. This should be indicated in a parenthetical at the end. So in 10.8.2, this Fifth Circuit split. So back in the 80s, the U.S. Court of Appeals for the Fifth Circuit was divided into Fifth and 11th Circuit. Be sure to look at 10.8.2 for information relating to that split. Now, 10.8.3, briefs, court filings, and transcripts. So, it's generally cited as the document name, and then the pin site, preceded by at. Then you'll have the case citation, followed by the docket number, no comma, in parentheses. And then a comma, and then you could have the commercial database identifier if it's available and it's optional. Be sure to always include the docket number, whether it's in a parenthetical or as the citation. And finally, short forms for cases. This is Rule 10.9. Okay, this is always a little bit tricky, and there's always questions about this, and I think it's important just to kind of quote the Blue Book in this situation. So in law review notes, the short form of case may be used if it clearly identifies a case, one, that is already cited in the same footnote, or two, is cited in either full or short form, and this includes id, in one of the preceding 5 footnotes. So having that in mind. Otherwise, if it's on the 6th footnote, a full citation is required. So we have an example here. Footnote 1, U.S. v. Montoya, cited in full. Second footnote, we can use an id, right? At with a pin cite. The third footnote, we have more new cases. The fourth footnote cites to Martinez, right? We can't use id because there is more than one case cited in footnote 3. So we can't use id. The fifth footnote, we have a new case. The sixth footnote, we can use id for the New York case. So in the 7th, we are citing to Hernandez, which we are in the first footnote. So this, why can we use the short form here for Montoya? We have, if we go back, we have the Montoya, we have 6, 5, 4, 3, 2. So within the following 5, including id, right? So is cited either in full or short form, including id, in one of the preceding 5 footnotes. So in footnote 2, we're using id to refer to the Montoya de Hernandez case. So we can use the short form there. Cohen is found in the 3rd footnote. So we're okay there. We have 6, 5, 4, 3. We're within that 5 there. Number 8, we have the short form for the Martinez Fuerte case, which happens in 3. So 7, 6, 5, 4. Sorry, it happens in 4 in short form, which is in the last 5. In the same California Bankers and the In Re case. So it gets a little bit tricky. There's a little bit of math involved. But just realize that short forms can be used if it's already cited in the same footnote or cited in full or in short, including id, in one of the 5 preceding footnotes. Now, in general, you only use one party's name, or what they refer to as readily identifiable short version of one party's name in the short citation. So, for example, they give as Youngstown Sheet and Tube Co. They shorten it to Youngstown Steel and Tube Co. Or Youngstown. Commercial electronic databases, this is Romanet 2. So the rule is here, cases that are available on an electronic database like Westlaw use a unique database identifier, if there is one, when you construct the short form. So they give the example of the Clark case. This becomes Clark, comma, unique database identifier, comma, at, and then the pin site. Same with the Albrecht case, becomes Albrecht, comma, database identifier, comma, at pin site. And recall that the short form uses italics. So decisions only available in printed slip opinions. So we have an example, Commonwealth v. Sam. So here it becomes Sam because we don't use government in the short form. We will use Sam, slip opinion, at 12. Now, there in B, there are two exceptions when using id. Is a short form for case citations. One, citation to the same case but to a different opinion. And two, citation to the same case where the case citation includes parallel authorities. So what does that mean? For different opinions. When an id refers to the same case but to the same and to the same opinion, then no parenthetical is necessary, right? But if it refers to a different opinion, then you have to indicate that in a parenthetical. So, for example, here's the Youngstown case. In footnote 1 and 2, we have id. And number 3, we have id. But now we're talking about the Jackson concurrence. We have to indicate that in a parenthetical. Now that concurrence becomes kind of the new id standard. So a subsequent id can refer to the Jackson occurrence. Now, if we're changing to a different concurring opinion, we have to indicate that again in a parenthetical. Now, if we're going back to the majority opinion, then we have to indicate that in a parenthetical as well. So now in the text, if we've already cited the case in full, in what Blue Book calls in the same general discussion, we can use only the party name without further citation. So this is Rule 10 cases. There's a lot happening in this rule, in this video. Feel free to come back to the video as much as you need. I hope this was helpful. We'll take a short break and move on to Rule 11, Constitutions. Thank you.